Normally, this matter would be taking place in an actual courtroom, and in a courtroom, the public is free to come in and out as they see fit. Secret courtrooms are dangerous courtrooms, to say the least. So because of COVID, obviously, I'm here in my chambers. We're doing this on Zoom. You have to have a password to get in. It doesn't allow for public access. The solution that we've come up with is to live stream our proceedings on YouTube. I'm telling you this for two reasons. One, I want to make you aware that I am in fact doing that. The other reason is I want to make sure you understand that there is no recording made of these proceedings. So if you're looking to have a record, you would be required to obtain a court reporter using your own resources, okay? Now that being said, what I'd like to do is to start by having just a brief discussion with you all. We're here for non-jury trial today. And the purpose of a trial is to bring your matters before the court, and I will make a determination based upon the evidence presented and the applicable law. Invariably, if you ask the court to resolve your matter at a trial, at least one party will leave this matter unhappy with the result. That is the inevitable result. Often, both parties are unsatisfied with the result of a trial. And I'm telling you this because as of right now, the matter is still in your own hands. I'd like to give you all an opportunity, if you wish, to have one last attempt at a settlement and to see if there's some mutually agreeable resolution to the matter. A settlement is not a win. A settlement is a guaranteed outcome that the parties can live with. And of course, the advantage being that you control what that outcome is. So I'll ask the parties, I'd ask you both, if you would like to take one more attempt to have a private conversation and see if you all can resolve the matter. And if not, we can proceed to a trial. Mr. Hoyt, would you like an attempt to speak with the plaintiffs one more time?
Oh, we're ready to proceed.
Very well. Oh, well, then it takes two to tango. So let's go ahead and have our trial. So let me explain how that works. At a trial, the plaintiff gets to go first because the plaintiff carries the burden of proof. That burden of proof is called the preponderance of the evidence. And what that means is if you start, at 50-50, you have to tip the scales ever so much in your favor. I don't know which or either of you would intend to testify, and I see you have a witness who would also likely testify. I'll have to swear everybody in. Once you present evidence to me, I have packets presented to me. Both this one's from the defendant. I have a binder from the plaintiff. You'll have to identify to me the items that you wish to enter into evidence. The opposing side can then object. An objection is not whether you agree with the contents of that evidence, but whether or not it's appropriate for the court to even consider that item as evidence. For example, a letter that is sent describing something or a photograph. Even if you disagree as to what that might mean, the question is whether or not I can even look at it and consider it as evidence. Once a witness is done testifying, the opposing side has an opportunity to cross-examine. And when the plaintiffs are done with their case, the defense can go ahead and present a case as well. And both sides will be given an opportunity for closing argument. Does either side have any questions about trial process or procedure?
Sir.
No? All right. All right. So Ms. Chris, who is there with you? I'm sorry, I have a little trouble hearing you. All right. Ma'am, I'm sorry, I'm still having a little bit difficulty. Are you using a laptop or a cell phone? It's a laptop. You might need to do something with the microphone. I'm having a bit of a difficult time hearing you. Am I the only one? Is it audio on my end?
I can't hear very well either.
I can't hear either, Your Honor.
It might just have to do with the direction of the laptop. Sometimes the microphones are set up to pick up sound right in front of it.
Sometimes.
Okay, we'll move a little closer.
That's much better. That's much better. I don't know what you did, but it worked better.
We moved it.
laptop closer.
There you go. Much better. All right. And who is the gentleman who's with you, ma'am?
My husband, AROSE.
All right. All right. Are you both going to be testifying today?
Yes, Your Honor.
All right. Then I'll ask both of you to please raise your right hand, and your witness, if you could also turn on your camera, sir. Mr. Clance, are you able to turn on your camera? Sir, can you hear me? Well, let me start with you folks, and then when he's testified, I'll swear him in. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
I do.
All right, please put your hands down. Before we go any further, thank you all for your patience and understanding with our technological issues. We're doing our best with the pandemic to allow court to proceed in as safe as fashion as possible. We may run into additional hiccups, technological hiccups throughout the course of this, and we'll all just do our best. All right. So, Mrs. Chris, if you would like to start, tell me why we're here. Tell me why you feel you're entitled to the award of the, I believe it's $8,000 in damages that you're seeking in your complaint.
Our driver and we have practiced the acknowledgement of the company.
I'm still having trouble hearing you.
Yes.
The microphone still isn't working. I'm sorry.
Can you hear me now?
Now I can.
Okay. The pavers, since we've moved in, have been chipping away. And we have asked them, as soon as we moved in, we noticed it and we asked them to address it. And they said that it was the type of pavers that the association had specified and that we needed to bring it up with the association. But the association really is them.
Okay. Explain it to me a little bit better. Why is it that this particular defendant, this the Estuary of Gray Oaks, who you named, Estuary of Naples Inc. Why are they responsible for this? And is it your driveway or is it the roadway? Because I saw that both are made from pavers.
It's our driveway, and they were the builder of our home.
Okay.
And the driveway, and we've had they brought in Kevin Keys from Keystone, who was the installer of the paver driveway, and he has indicated that it's the improper paver for a vehicular application. Then they also brought in the representative from Belgarve who manufactured the paver, and the manufacturing rep also indicated it was the improper paver for this type of application.
Okay.
And then we hired the engineer who tested Paul Clenz, that's our expert witness, and they tested the pavers and said there was nothing wrong with the paver. It was a problem with the design and the application of the paver.
Okay. So nothing inherently wrong with the pavers themselves.
Correct.
They were just not intended to be used as driveway pavers.
Exactly.
Okay. Were these pavers standard for the community, or are they something that's selected by the individual homeowners?
We were the last house to be built, and this was all through builders or Lucker Construction that specified it.
Okay.
They're all the same.
All right. All right. So go ahead. Please present your case at this time.
Well, pretty much the whole notebook that I had presented to both you, Judge Brown, and to the defendant. From the beginning, it shows the pictures of we're here half a year, and how the pictures are showing how it's continually breaking away day after day. It's breaking away, and we have a side load garage on top of it. So when you pull in, you're turning, and the pressure from the vehicles are just scalding.
Okay.
We have in the notebook, it shows the exhibits are of the letters from Kevin Keys, the letter from Christopher Moore, who was the Belgarve representative, the testing that we had done with Paul Clens with the W.J. Johnson engineering firm, the letters from Lutker's attorneys saying that it was not our problem, was not their problem, it was our problem because it was our association that specified it. But everything in there goes back to show from the very beginning, the estuary, the Marsh Rent Association, it all comes down to it was them who developed all this.
All right.
And specified what was used. We had no choice on what kind of pavers to use.
Okay. I mean, there's a lot in this packet here. Are there specific things that you're asking me to accept and admit into evidence at this time?
Well, Exhibit C for sure. That shows all of the letters from Keystone and Belgarve.
So, Mr. Hoyt, did you get a copy of this binder?
I did.
Have you had a chance to review Exhibit C?
I have.
Do you have any objection to me accepting the contents of Exhibit C into evidence at this time?
If you give me one moment, I'd like just to flip back through it to see if there's anything I object to.
Sure.
No, Your Honor, I have no objections.
All right. Then, Tommy, for the record, what I'll do is I'll take the contents of Exhibit C, I'll mark them as Plaintiff's Composite 1,
Okay.
and I'll submit that to you as evidence, okay?
Okay.
Thank you. All right, so let me take a look at it now that it's in evidence.
Okay.
Okay, who is Kevin Keys?
He's the owner of Keystone Paving, who was the company that installed the driveways on Marsh Run.
Okay. All right. All right, I've read all of the documents. Yes, ma'am.
In Exhibit A, that just shows the fact that we had started to ask them to take a look at the situation when it was still under their general warranty. Numerous emails.
Mr. Hoyt, please take a look at the contents of Exhibit A and let me know if you have any objections. While you're doing that, ma'am, when did you first move into the home?
We took possession at the end of April of 2017.
And when did you first notify the estuary of Gray Oaks of the
June 15th of 17.
Okay, thank you.
Your Honor, no objection to Exhibit A.
All right, Tommy, Exhibit A in its entirety will be admitted at this time as Plaintiff's Composite 2.
Okay.
Okay. Ma'am, go ahead.
Yes, then Exhibit B is the response from their attorney stating that the pavers are in accordance with the Marsh Run Community Standard and requirements for driveways.
Okay.
There is nothing improper in the use of these pavers for driveway installations.
All right. Mr. Hoyt, objection to Exhibit B.
No, Your Honor.
All right. It'll be admitted as Plaintiff's 3.
And exhibit C. Shows all of the-
Oh, ma'am, your microphone is cutting out again.
Exhibit D as in David
Yes.
shows throughout the course that the Leckert company was the developer, the builder, and the association. The declarant, I believe they call themselves.
Mr. Hoyt, please review and let me know if you have any objection.
Your Honor, the last page of Exhibit D, there's handwriting at the top that says below shows Lutkert was association, et cetera, et cetera. I'm not sure what this is from. Where does this document come from?
That was my own kind of summarizing
You
the
generated the
facts.
Okay. All right, Mr. Hoyt.
Okay, no objection.
All right, to the entirety?
That's correct.
All right. Then Exhibit D will be admitted as Plaintiff's Composite 4. Okay.
And then Exhibit E has our attorney that we were using, Rob Samoose, and then Leckert's attorney, Mr. Neil Gregory's response, and then the W.J. Johnson engineering firm, the test results, and what our expert witness, Paul Klein's comments were in his letter regarding the condition of our driveway, which was back at that point done at his inspection in May of 2019, and we're almost 2 years past that date at this point.
All right. Mr. Hoyt, just let me know if you have any objections.
No objection, Your Honor.
Then Exhibit E in its entirety will be admitted as Plaintiff's 5, Composite 5.
And then finally, Judge Brown, Exhibit F just shows the lack of customer relationships that we have received with them going as far as using words all the time and just not a very admirable way to conduct business.
Detroit?
I object.
All right. Yeah, I don't, no. That's not relevant. All right. Okay. Yes, ma'am. Any other, documents, exhibits, anything else you'd like to introduce?
At this time, other than, if you have any questions for our witness.
There were some photographs that were included in the package.
Oh, yes. Those I'd like to have included as well. First time doing this, Judge.
It's okay. Mr. Hoy, did you get a copy of the photographs?
I did. I got a copy of are numbered on the back.
The exact ones.
Varying sizes, photographs from up to 21 photographs.
All right, I've got 1 through 11 of the larger format, and then looks like through 21 of the smaller format ones. All right, any objection to are these photographs of your driveway?
Yes, they are.
And who took them?
I did.
Okay. Mr. Hoyt, any objection to the photographs coming in?
The only objection I have is that there's no way of telling if these are from their driveway.
Right. Well, that's why I asked the question. So, Ms. Chris indicated that these are her driveway. So.
Okay. Well, if we have to take her word for it, then the only other objection I would have is, well, we could talk about them once they're included into evidence.
For the admissibility of evidence, all it requires is authentication, which is essentially someone saying, these are what they purport to be. All right, that's authenticating that these are pictures of the relevant issue, and she's telling me that. And so for admitting the photographs so I can look at them, yes, that is sufficient. Sorry, that was a long way for me to get there, but
sorry, understood.
All right, let me get my clip for that. All right, so once again, this will be then composite 6, plaintiff's composite 6. All right. Any other documents you wanted to introduce?
No, thank you.
All right. Did you want to bring in your witness and have him testify? Mr. Chris, did you want to? Is there something you were going to testify to before we have the expert witness testify?
Yes,
Your Honor, the only thing that I'll add is regarding those pictures. Mr. Clems has physically been to the property numerous times, so he can testify that those are the pictures of our driveway. And then I'm not sure in which exhibit it was. My wife Karen mentioned about Kevin Keys from Keystone in an email saying they were the wrong pavers for the application. Also in that exhibit is from Belgard, the manufacturer, in an email saying that those are the wrong pavers for the application.
All right, thank you.
Thank you.
Mr. Clems, are you there?
I don't think you can see me, Your Honor. My camera doesn't seem to be functioning properly. I'm actually speaking to you over my cell phone.
All right, then we'll do our best to do this over the phone. Sir, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Very well. All right, Ms. Chris, I don't think you need to hold up the cell phone to the camera. All right. So, ma'am, go ahead. This is your witness. The way this works is you ask him questions. All right. So go ahead.
Can Al ask him?
Yes, of course.
Okay, he's had more contact with him.
No problem. Go ahead.
Well, I just want Paul to explain to the court his findings of what he witnessed and his experience and his credentials regarding the application of the paver for the driveway.
All right. Mr. Clems, I can't hear you. can't hear Mr. Clens. Is that why you're holding the phone up? Is he on your phone? Oh, this is, all right, we're gonna add a layer to this, huh? Mr. Clens, if you can't get into Zoom, I can give you a phone number that you can try to just call my office directly, and I'll put you on speakerphone. I prefer Zoom so I can see folks, because this is a trial setting, but if we can't make that work, you can just call my office. All right, let's do this. I can't hear him. If you can pass along, if he can't hear me, if you can pass along the following number.
Okay, what is that?
239-252-8114. And my assistant Sarah will answer the phone, and she will patch him through to my desk, and I can put him on speakerphone so we can all hear him. Okay, all right.
Okay, 1 moment.
And let me just let her know that I'm expecting a call. Be right back.
Very good, thank you.
Mr. Clens is good. Well, just talk to me. We'll have you Zoom with you, so he's gonna call you. Back to All right. She'll patch him through as soon as he calls.
Thank you.
You have no idea how much I'm looking forward to going back into my courtroom. There we go. Hello?
I hear you.
All right, thank you.
Okay.
Mr. Clens, can you hear me?
Yes, I can. Can you hear me?
Yes, sir. I can hear you much better now. Thank you so much.
Good.
All right.
Yes, the Chris has contacted me. I do quite a bit of work in Gray Oak. I'm a Florida licensed landscape architect, have been ever since 1996. I have done hundreds and hundreds of thousands of square feet of interlocking concrete pavers as well as other paving materials. Well familiar with the industry and the special conditions that we find here in Southwest Florida. The biggest problem I've found with back up, I collected physical samples and sent them to GFA International, which is the materials testing laboratory. They tested the materials on the 12th of June that year. And as far as the material went, there was no problem with the material. It met the Interlocking Concrete Paving Institute standards for pound per square inch compressed strength and dimensional stability and all of this stuff. The biggest problem that we have with these pavers is that all interlocking pavers have ridges on the side, which tend to separate pavers from each other and keep the faces of the pavers from binding up against each other, and also provides space for fans to form in to fill in the void, which not only cushions the pavers from each other, but also helps to lock them in place.
Okay.
The pavers in the Chris driveway do not have these ridges. So these pavers, both with the diurnal heating and cooling of the day and with the turning motion of vehicles, are constantly grinding up against each other, which is causing all sorts of spalling around the perimeter of the pavers, and it's widespread. It was widespread the first time I visited the Chris residence, and I believe the pavers were less than 2 years old at that point. And I was there approximately 3 weeks ago in preparation for this Zoom meeting, and the situation has continued to deteriorate.
Okay. Is there any way with the current pavers to mitigate the damage, or is it just because of the nature of these pavers without those ridges, there is no way to do anything other than replace them?
There are two answers to that question. One is there's really no way to mitigate the damage because this particular product has been discontinued. So it would be impossible to match the color, and possibly there might even be some dimensional issues. Secondly, if the exact same paver were put back in it would just be a continuation of the problem we're seeing right now.
So there's no method of installation that can solve the problem?
No, I don't see one. There isn't enough space in between the pavers because they lack the ridges. We can't get a cushioning or interlocking layer of sand in there.
I see. So I guess, so I make sure I understand you correctly. It is an application issue, not a manufacturer or installation problem.
Like I said, Your Honor, the material meets the Interlocking Concrete Paver Institute standards for compressive strength.
Okay.
I don't know if it was a manufacturing glitch. I've never seen interlocking pavers that don't have these spacer ridges on the side. I wouldn't use these even in a sidewalk, because even with the even if it wasn't a vehicular area, just the diurnal heating and cooling of the day is going to cause them to expand and contract. Right. And they're going to continually grind against each other.
Okay. All right. Mr. and Mrs. Chris, any other questions for this gentleman?
Just
One thing, Your Honor, we had a company by the name of Boness, who's been around the Naples area forever, come out for a quote, in the replacement of the driveway is $14,700, and that was included in the packet that my wife Karen sent. So the case here will still be out about $7,000 after our attorney fees and engineering fees and so on and so forth.
All right. All right. Anything further?
No, I'm fine, Your Honor.
Sure. Mr. Hoyt, do you have any questions for Mr. Clens?
Yes, is there any reason that we should be swearing in Mr. Clens?
I did.
Oh, I'm sorry, I missed that. Okay, my first question for Mr. Clens would be is that he mentioned that there's no way to mitigate the damage of this. And he mentioned that one reason is because sand, which is typically used to keep pavers from moving, he said there was no room for it between the pavers. And I would like to draw your attention, court's attention, Mr. Clens' attention to the photos.
Well, hold on, before you do that, Mr. Clens, do you have a copy of the photographs that were given to us by Mr. and Mrs. Chris?
If you can hold up the photograph that you're looking at, I can tell you.
Oh, you can see us?
Yes, I can see you.
Ah, very good. All right.
Okay, so this happens to be photograph number 1 on the back. And as you note in photograph number 1, the joints seem to be of varying size. So again, lower right-hand corner of the photo, a joint there that hard to tell because we don't know the scale of the picture, but it's certainly different than that of some of the other surrounding joints. And then they all vary in the way that available space between pavers. This is true if you go through all the photos. So, Mr. Clens, is it your opinion that the pavers were set without sand between them at all?
I know they were because we removed pavers from the driveway to take them away for testing. And there was no evidence that there was any interlocking sand or cushioning sand between them.
Okay. And then what would be your recommendation for maintenance of any type of paver application?
For maintenance?
Yes.
Periodic pressure washing is usually all that's required.
And during a pressure washing, is it not likely that sand between the joints would be lost?
Probably not, because you're pressure washing from the surface. I know there have been some paver contractors who have recommended periodic resanding, but it's usually no more frequent than once every 5 years. Some people put a sealer on their pavers, especially in driveways because of oil stains, and that tends to lock the interlocking sand in place.
Mr. Clens, do you know what the Concrete Paver Institute recommends regarding sanding and maintenance?
They mentioned that it's a situation by situation decision. If it appears the pavers are becoming loose for whatever reasons, whether it's excessive erosion or excessive traffic or whatever. However, you know, we have paver installations in this part of the world that go back 20 years, and they've never had to resand them. Usually there's enough sand just floating around in the environment that it takes care of that issue for us.
And maintenance would have an impact on the longevity of those joints, correct?
More the surface of the plant or pavers than the joints themselves.
So is it your opinion that the maintenance would have no impact on the sand between the pavers?
That would be my opinion, yes.
Okay. Mr. Clens, you mentioned that these pavers were discontinued. Have you confirmed that?
It was confirmed in letters and documents that I have in the CRIS file that they turned over to me when I first started working for them.
Can you point to those? These are letters that are included in the record today?
I don't know if they included them or not.
Okay. Well, if you don't mind, I'll take a moment to read a couple of those letters to you.
Take your time.
Mr. Wright, when you find them, just let me know which ones you're looking at so I can look at them as well, please.
Yes, sir. I'm looking in Exhibit C, and it, in my package anyway, is the last email in Exhibit C. And since Mr. Clens, do you have those in front of you?
I do not have that binder.
Okay, well, it makes it a little more difficult, but I'll read it to you. The last paragraph of that memo says, due to the fact that this particular paver is no longer a standard production item, a 3-pallet minimum will be required for the manufacturer. Does that tell you that that paver is no longer manufactured?
I do have that email, yes, I do have that.
Does it say that that paver is discontinued anywhere?
That email does not say that, no.
Is there another email or a letter that you're aware of that does say that?
That's something the Chris's are going to have to answer.
Well, you said that during your testimony, that part of the second reason that this is not something you could not mitigate was because this was a discontinued paver.
And I'm looking for it right now.
Do you want to change your testimony?
Let's see here. I do know that the color wouldn't match because of the age.
Correct.
Is there an allowable color variance according to the Concrete Paver Institute or ASTM?
No, there is not.
There's no zero tolerance for color variance.
That's true, and that's why when you order papers, you want to order them all on production run, so the color blend, and that's also the reason they call it a color blend, all lines up correctly. They also recommend that if you're going to order extra additional pavers after an installation, that you store them outside so that they tend to weather at the same rate as the pavers that have been installed in the driveway or roadway or whatever it happens to be.
Are you still looking for that memo that says that these are discontinued?
Yes, I am.
Your Honor, may I speak?
Well, it depends on what you want to say, because this is Mr. Hoyt's opportunity to question the witness.
Well,
Yeah, we don't need to coach Mr. Clens.
Well, no, it depends on what he's going to say.
will not match the issue. Your Honor, in the email that Mr. Hoyt is referring to is, and we have an email in hand.
I'm sorry, I lost your audio again.
Okay, I'm sorry. It should be noted that any replacement pavers will be from a new batch, and although they will meet the standards of for the color variants, they will not match the existing pavers exactly, possibly creating a new visual issue that could be more of an issue than anything that currently exists.
All right. Okay, I see that.
And that's from their superintendent.
Got it. All right, go ahead, Mr. White. Please continue.
I was seeing if Mr. Cleanser coming up with an email or a letter or something that says that these pavers are discontinued, because we're not aware of it.
But an email here talking about the inappropriateness of this product.
That's not what I'm asking you about. I'm asking about the paver itself. You said one reason it could not be mitigated is because it is discontinued.
I'm looking for it. And you know, now that I'm not sure if that was something I was told or if I actually have an email, but I do have an email here from let's see, from Rob Samus, talking about the inappropriateness of Belgrade. As stated by the paver manufacturer, Belgrade, the pavers installed in your driveway do not have spacer ridges or chamfered edges and are therefore unsuitable for a vehicular application. I'll go further and state I never would specify a paver without spacer ridges for any paver applications, as the sort of chipping and spalling is very likely to happen due to lateral compressional forces from vehicular movement, expansion due to heating in the Florida sun. So on that basis there alone, whether there's a color variation or not, this is an inappropriate product.
So that's the letter you were reading from was from the Chris's attorney, correct?
Yeah.
Is the Chris's attorney an expert in concrete pavers?
He's an expert in construction law.
Law, thank you. Okay, my next question is concerning the color variance. Oh,
I have one quick clarifying question. I'm sorry to interrupt. What is a chamfered edge? Please explain it to me.
Chamfered edge is sort of a rolled edge where sometimes it's called a pillow top paver, where there's an angle cast into the all around the perimeter of the top edges of the pavers.
In order to keep the edges from rubbing against one another.
Well, no,
Or is
it's the
this
ridges that are on the sides of the pavers that keep them from rubbing against each other. It's more of a design feature.
Okay. All right, thank you. I just wanted that cleared up. This is not my area of expertise. So go ahead, Mr. Hoyt. Please ask your next question.
My next question has to do with, I think you just testified that the color of an additional batch of pavers would not match the existing, correct?
That's correct.
And you said that there's absolutely no color variance allowed for either through the Concrete Paver Institute's standards or the standards under ASTM, correct?
No, the ASTM standard and the Interlocking Concrete Paver Institute recommends that you have all of your pavers run as one manufacturing process, so that they can get the color blend consistent throughout that run. And it has been my experience when we've gone back and tried to reorder additional pavers that weren't from that original run, even though it's the same color blend, there's usually a noticeable difference between the older pavers and the newer ones.
That wasn't my question. My question was, either one of those governing institutes have no standards for color variation, have absolute zero tolerance.
No, they do not have a zero tolerance for it. I mean,
Okay, so they allow for a color variance. So then my next question is, if you take a look at picture number 16.
Answer the question. Let me answer the question. In pavers that are solid colors, like a brown or a tan, or in the case of the crisp, where they're generally a light sort of cream, maybe gray color, those colors are easier to match than multicolored pavers. But there are certain color blends that are always used because they can't get them exact. Now, what you will notice if you order pavers a couple of years after your original installation, and you put them down on top of the existing pavers, you're going to see a difference. And one of the reasons that people go with concrete interlocking pavers is for the aesthetic. So if there's a difference in the color between new pavers and old, that kind of defeats the purpose. And the ICI and ASTM have standards for manufacturing as well as color matching.
They do. So do those standards allow for a variance in color?
It's very, very minor if there is any. I'm not aware of any.
So you're not aware if they allow for any color variance?
No, I don't.
Okay. So my next question then is, if you take a look at picture 16, it's a smaller format picture. I'm holding up in front of the camera now.
Your Honor, if you could hold that up, I can see you much better.
Sure, give me one moment. All right, this is 16. I think I'm holding it up right here.
That looks like the same. It's got shadows over on the left-hand and left-hand top corner.
Everyone see that okay?
That's the Chris driveway.
Okay.
Okay, so is this a picture of the paver installation at the Chris's driveway?
Yes, it is, and that's the color blend.
So are those colors one standard color in there?
No, it's a color blend.
So would it be your opinion that a paver manufactured later could not ever be used to blend in with this color variation, that is the picture that shows the pavers in the Chris's driveway?
It's my opinion that no paver manufacturer, and in this case Belgrade, would be able to match that now.
Further questions, Your Honor?
No more questions?
No more questions.
Okay. Mr. and Mrs. Chris, do you have any redirect, any additional questions for this gentleman?
A comment. What was going on with
No, I'm sorry. I'm having problems with the mic again.
The color is not the issue. The application and the chipping and spalling is the issue. It's not the color.
I'm sorry. I did not catch that. I apologize.
Okay, I was just saying that the last cross their examination was all about, or mostly about color issues and making it blend in to replace. You're not going to be able to replace the same issue because the same pavers, because we're going to have the same issue.
And it's the wrong paver. So even if
It's
they,
the wrong
if the
application.
color matched perfectly, would not make a difference, because every week we get new chipping and spalling.
So I understand.
Yep.
Thank you.
Did you, in one of these packets, because I haven't had a chance to read every bit of it already, is there an estimate as to the cost of the replacement? Or have you already done a replacement?
No.
No, we haven't.
I'm sorry, I need you to point the microphone at you.
It was in the package under, when my husband spoke earlier, Bo Ness was the company that came out, and they estimated $14,705.62.
Where am I going to find that? Which exhibit was that contained in?
One moment, please.
Were you able to find it? I can't hear you.
Very beginning of the notebook in the mediation section, the second or third page.
Well, that's not in evidence at this point. Was that something you were going to enter into evidence?
We're allowed to do that now?
Well, your case is not closed.
Okay, because like I said, this is all new to us.
No, it's okay. All right.
Yes, we'd like to add that mediation section.
We can email it.
Oh, there's a section called mediation. All right, Mr. Hoyt, what they're referring to is there's a document where on the top left it says bonus.
Yes,
Do you see that document?
I do.
Do you have any objection to that document being entered at this time?
No, Your Honor.
All right, so that'll be entered as plaintiff's 7. Anything else regarding mediation, I absolutely cannot accept because mediation is considered confidential, and it'd be inappropriate for me to consider anything from the mediation. Okay, but this is an estimate, and so this will be admitted as plaintiff's 7. Is that correct, Tommy? We're up to 7.
That's correct, Your Honor.
All right, plaintiff 7. So this is for replacement of the entire driveway. Is that right? Okay. All right. Anything further?
Well, once again, just coming back to Your Honor, coming back to saying, even if you were to say you could match the color, et cetera, it's still the wrong paver for the application. And every week or day goes by that a new spalling or chipping occurs. So if the same product were to be used, we would have the same issue.
Sure. All right.
That's it from my end.
All right. Very good. Mr. Hoyt, this is your opportunity then to present the defense's case. Go ahead, sir.
Okay, as I go along, then I'll provide documents to submit for.
I've got your packet as well. Yes, sir.
Okay. I've got several points I'd like to go across, probably 12. First point is a little summary. Marsh Wren Neighborhood Association contains 39 homes
Okay.
on the street. Second point is that all 39 homes in that neighborhood had the exact same pavers in their driveways, paver bricks in their driveways. Third item is the first home in that neighborhood closed in 2005. Since then, other than the Chris's, we as a developer and contractor have had 0 complaints provided to us concerning these pavers. 0. The Chris's closed on their home April 27th of 2017, 12 years after the original home was completed. It was the very last home in the neighborhood to complete on that street. There was plenty of opportunity for the Chris's to see the performance of these pavers in 38 other driveways before they went to contract on their home. Item number 5, started construction of their home in June of 16. Number 6, 13 of the 39 homes in the Marsh Wren neighborhood have side loading garages exactly like the Chris's. So they are by far not the only driveway that is a side loading driveway. And of those other 12, we've had 0 complaints for warranty items on those pavers. Item number 7, which I would like to submit an item into the evidence, and that is the document titled Estuary Gray Oaks Top Standard Warranty.
Okay.
You have that document?
Yes, sir.
This document under item 2 has a section for exclusion from coverage. And item A is imperfections that result from characteristics common or inherited to the materials used, cracks which can occur in a normal drying and curing of concrete, stucco, plaster, bricks, or masonry, normal drying and shrinkage of materials, color and grain variations in wood, stone, and other products. That's A under item 2. Very clear about what is excluded there.
Hold on. Mr. and Ms. Chris, any objection to this document, the standard warranty being admitted as defendants 1?
Yes, Your Honor, where Mr. Hoyt is saying plaster bricks or masonry, we're not talking about bricks, we're talking about pavers.
Well, that's a separate issue. Whether or not the warranty applies under these circumstances is a different issue. The question is, can I read and look at this document and consider it as evidence?
Yes. I'm sorry, Your Honor.
No problem. This will be admitted as defendants 1. Go ahead, Mr. Hoyt.
Okay, so that's item 2A. And of course, bricks are obviously the concrete brick pavers. That is the only location in this home that a brick is used, no other location.
Okay.
Under item 4, claims procedure. Under that paragraph, there is a bold paragraph. Bold letters, large type, says this warranty is the only warranty extended to buyer by seller. All other warranties expressed or implied, including the warranty of merchantability, fitness for a particular purpose, are hereby disclaimed. So that's the warranty that was included with their sales contract.
All right.
Item 8. As Chris has pointed out, both the installing contractor and the manufacturer's representative of the bricks provided their expert opinions into their issue and provided letters. So I would like to submit into the record email dated May 21st, 2018 from Stephen Parker to the Chris's, and it has the Belgard logo at the bottom left corner.
Give me a moment. May 21st email?
May 21st, 2018. Yes, Your Honor.
Yep, got it. All right, any objection to this being admitted at this time? Mr. and Mrs. Chris?
No.
All right, this will be admitted as defense 2.
One of the Chris's have pointed out that Belgard has opined on this. They said that this particular series, the Jericho Stone 4-piece product, has a non-chamfered edge, as we've talked about, no spacer bars on each paver. In a vehicular application, the force from even residential traffic can cause pavers to rub together against each other, which may result in chipping and or spalling.
Right.
His next sentence says, I saw no evidence of an installation issue and no settling or rutting. The next sentence says, I also walked several other driveways on this street and everyone had the same issue to varying degrees. If you have any questions, blah, 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 call us. So that was the Belgard opinion on their issue.
Okay.
The next document I'd like to enter into the record is an email from Stephen Parker, April 20th, 2018. And you have that in front of you.
And Mr. and Mrs. Chris, any objection to this being admitted at this time?
No.
All right, this will be defendants 3.
In the first paragraph there, Mr. Parker, our project manager, provides information to the Chris's. This is according to their opinion. This is after having Keystone Paving review the driveway. He's reiterating what their opinion was, and that is that the ASTM standards, according to their opinion and ASTM standards, the majority of the issues in your driveway do not meet the necessary criteria for replacement. Keystone estimates that there is less than 100 square feet of driveway that could possibly meet the criteria for replacement. And it should be noted that there has been no objection to this opinion since it was issued back in 2018. Second paragraph said, should also be noted that replacement pavers from the new batch, they will be from a new batch, and although they will meet the standards for the color variants, they will not match the existing pavers exactly, possibly creating a new visual issue that it could be more of an issue than anything that currently exists. It's also obviously very important for us to provide this type of information to homeowners who are very particular,
okay,
so that there is no misunderstanding. And then the last paragraph says, due to the fact this particular paver is no longer a standard production item, no longer a standard production item, a 3-pallet minimum will be required to manufacture, and it will be done, and they can start it once they can fit it into their schedule.
Right.
If you decide to accept the possible color variances and the paver performs similar to what you see now, they'll have to get back to you with expected replacement time. This same email is the attachment of what Kevin Keys sent to us. And Kevin Keys is the installing contractor. He also happens to be the local representative for the Concrete Paver Institute. I'm sure that would be valuable for this type of discussion. 2 areas of concern: the chipping of the pavers and the settlement of the pavers was a pool deck issue. So we know that that's not a point here.
Right, we're not dealing with the pool deck.
Right. So the chipping of the pavers in the driveway is caused by the selection of the pavers. The pavers selected in the Belcar Jericho series are not being used as they were intended.
Right.
Doesn't say are prohibited for this type of use, but not being used as intended, in his opinion. The pavers are a non-chamfer paver, and this style of paver was originally made specifically to be used as a tumble paver. That would be, they'd put it in a machine, tumble them, and it would chip up even more. So they wouldn't have these issues that you could see any variance in them. Because there's no chamfer and the pavers are not tumbled, there is nothing preventing the edges and pavers hitting each other and causing chipping has occurred. Consideration in this size of chipping has occurred. The other consideration is the size of the chipping that has occurred. Per ASTM C902, the chip needs to be larger than a quarter when seen from 25 feet away to be caused for rejection. This is not the case in the majority of the chipping. The other issue is the pavers and center in the pool deck, so we're not talking about that. Nothing else we need to cover in this particular email.
Okay.
Okay, let's see. So we covered in that last one about they said that the area that did meet the requirements again was less than 100 square feet at that time.
Okay.
Okay. I had a couple photos included in here. They're all listed as by address. One of them, actually, the main photo at the beginning is a photo of the street. The purpose of that photo is to show maturity level of the landscaping at this point. But the point is that landscape was all installed at a very mature level, as opposed to at minor amounts at installation and sale of contract. The point is that that's how the community was meant to be seen, as a mature community from the beginning. Certainly back from 2005, and then certainly back in 17 when they closed, and 16 when they bought. So that's the first photo. The second photo is at the top. Address is 517 Marsh Run Lane. As you can see with the mailbox in the background, it shows the street pavers and it shows the driveway pavers. So you can see from this distance, the distance recommended by the ASTMs for viewing what these driveways look like. And this 517, the first page is 1, and there's pages 2 of 2. So we have both of those. We did the same thing for address 1525. It's a side loading garage. The distance is a little closer than the ASTM specification. It's still worth noting what they look like from that distance. 1528, the mailbox on the front page, page 1 of 2. Street pavers, driveway pavers. The next page is 1528, page 2 of 2. And that's that driveway, again, a side loading driveway or garage. And then 1552. Again, with the mailbox inside there, you can see the street paver, the driveway paver, and then also some sidewalk pavers beyond it. And then the second page is, of course, of the driveway. The important thing to note in all those is the pavers all are exactly the same. They have the same variance in color. They perform the same way. and many of those are side loading garages, just like the Chris's.
All right, so you want these photos and evidence?
Yes, sir. Yes, Your Honor.
All right, then any objection, Mr. and Mrs. Chris? All right, then the photographs will be entered as defendant's composite. Let's see. 4. All right.
Okay. It may have been one of the previous emails. Let me double check this point. Yeah, it was the previous email we entered into it. That was the May 20th, 2018 email from Stephen Parker to the Chris's. It should be noted on that email that we offered to replace those pavers that do meet the criteria for replacement according to the ASTM standards. Back in 2018, 3 years ago, roughly, we could have resolved this.
Okay. All right.
Okay. The 11th point is of the photos submitted by the plaintiffs, which I believe there's 21. The 2 different sizes, we went through those earlier. We don't need to go through those in detail if you like, and we'll leave that up to the Chris's, but it should be noted that many of these photos are duplicates of each other. So I'll start by flipping through there and say that photo number 4 is basically the same photo as number 1, different direction, a little further away. Certainly not the 20 feet that's required by the ASTM, but shows the same issues. Go on to photo number 5, same thing, same as photo number 2. Again, different direction, little different perspective, same issue, same chips that you're seeing in the bricks there. Photo number 6, the same as number 1 and as number 4. Again, different direction, same chips. If you study these photos, which we just have to take a couple minutes to flip through these, and I certainly would not say they're exhaustive, but we noticed that there was duplication in all of these that I'm mentioning. Number 7 duplicates number 2 and number 5. Number 9 duplicates number 2. I got this backwards. Let me flip through them here real quick. I go through in order. Number 12 duplicates number 2, number 9, and number 13. Of course, number 13 then duplicates number 12 and number 9. Number 14 duplicates number 12 and number 13. Number 17 duplicates number 1 and number 4. Number 18 duplicates number 17, number 4, and number 1. Number 19 duplicates number 10. Number 20 duplicates number 17 and number 1. And 21 duplicates number 1 and number 14. Now, this certainly is not an exhaustive review of these photos. The point is here to show you that these are not individual different items on this driveway. These are all very much the same items that they're taking multiple photos of. So again, we go back to the review by the expert that said that there was about 100 square feet that met the requirement for replacement when reviewed by the industry standards. Brings me to my next point, the cost of replacement. I've been a general contractor for over 30 years. I've installed miles of concrete pavers, bricks, all through Mercado. Those are all our projects, all the high rises, Park Shore, Bonita Bay, Promenade, brick pavers like you wouldn't believe. The cost that we use to estimate them at this point is still about $5 a square foot to replace. So at this point, 100 square feet is cost about $500. Let's give them the argument that, hey, we got to take some pavers out. It's not just lane pavers. Okay, give you 50% more cost, $7 a square foot, $750. It's $750 we're talking about here to replace the pavers that meet the industry standards for replacement. So what they're asking for, in our opinion, for cost is way beyond betterment. And then what I'd also like to bring up is the plaintiffs brought up that, and their witness said that this was the wrong paver to use. Nowhere from the industry standards, the manufacturer, or the Concrete Paver Institute's representative does it say this is the wrong paver to use. Certainly, after you've had 38 other homeowners have it for more than 12 years and nobody complains, can't be all bad. We're talking about homes that average at time of construction between $1.5 and $2.2 million. Certainly not a discerning, or certainly is a discerning customer. And we would have heard from somebody had there been an unusual amount, unacceptable level of performance of the material. And again, being with the Lutker companies for over 26 years now, we deal with that type of customer all the time. And we know that we hear when there is an issue. So nowhere in the documents that have been put into the record, anywhere does this paver prohibited from use in this application. Nowhere.
Well, it does say, it says that the pavers selected are not being used as they were intended.
Yes.
And it does indicate that, where did I see that? The other letter. The letter from, looks like Mr. Moore, or the email from Mr. Moore. It says, I also walked several other driveways on the street and everyone had the same issue to varying degrees.
Correct.
So it does say, it does indicate that this seems to be a problem with these pavers, especially if it's the same pavers that's used throughout the, you know.
But it can't be defined as a problem. Is an issue, yes. A problem, no, until it meets the industry standard for replacement. Okay. Just because there's a crack in the edge of a paver, it's a concrete paver. Concrete pavers crack. It happens. I don't care what type they are, how they're installed, there's going to be some cracks in them. And when you have to define it as a replacement problem, they have to meet the industry standards for that.
All right. I see.
I'm finished.
Very good. All right, Mr. and Mrs. Chris, you have an opportunity to present a brief rebuttal argument or any additional evidence, and then I will make a determination. Go ahead. But I need you to point the microphone to you.
Okay, thank you. On theirs, I would like to ask Mr. Hoyt, that estuary standard warranty, is that specifically for the Marsh Rent Association, or do you use that elsewhere?
This was specific to your purchase contract.
Okay. When you look up what a brick is and you look up what a paver is something that is on exterior flooring, and a brick is on a wall. I want to make that point. The other point about you're saying that there are no other issues. The very beginning statement from the email from Kevin Keys from Keystone Paving says, we have some continuing issues at the Villa Fabiana on Marsh Ren, the chipping of the pavers of the driveways. Have you ever not had anybody else on the Marsh Ren street have ever come back to you and asked about the pavers being chipped?
Nobody.
Nobody. Okay, nobody in your company.
Nobody that I'm aware of other than you.
Okay, well, we have a lot of neighbors that have been talking about this, and they said that they have contacted you, and you get the same runaround that you've given us about it was the association that specified it, and they didn't check and go further, and maybe Al and I did go further to realize that you really were the ones. If you travel through any other street in the estuary, including Noble Heron, which has the other villa style homes on it, not one other street has a chipping problem. The only one is Marshman. So if you would like, there might be a lot more people on our street that would like to discuss this with you. As far as the pictures, yes, there are pictures taken from different angles because sometimes the sun was here or there. But the 1,000 square feet or whatever you're talking about was 3 years ago. It's 3 years later, and what's going to happen 3 years from now? And we're only here half a year. I mean, this is an ongoing thing, you know. I don't know why you can't just stand up to the fact that this is wrong and make it right.
Well, ma'am, this is the arguments have to be
I'm sorry.
No, I understand. It's all right, but at this point, you know, this discussion has to come to convince me
Anything else?
to this.
Can Mr. Clems, I don't know if he has any
Sorry, you still
comments after Mr.
Yes,
White's.
I'm clear.
Yes, he's still there. Well, do you have a specific question for Mr. Clems about anything that
No,
would?
if Mr. Clems has any questions to Mr. Hoyt with what he was talking about from the standard and ASTM and et cetera, et cetera.
No, I have no questions for Coy.
No. All right. Ma'am, I'm sorry, I cannot hear you.
Paul, when you were here 3 weeks ago and examined the condition of our driveway compared to when it was, I think you did mention that when you first came out 3 years ago. What is your interpretation of the condition now?
It's definitely gotten worse. The chipping and falling has continued. It's much more noticeable. I would say that the chipping and falling that I witnessed around the perimeters, the edges of the pavers, are easily the size of a quarter. I dispute whether or not it's legitimate to say that if you can notice it from 20 feet away, that it's not significant. It's a failure in my mind. And like I said, from the material testing, it's not a material issue. And we have documentation that this is not the right application for this paper.
All right.
And I have one last comment, Your Honor.
Yes, sir.
We did not take Mr. Hoyt's offer of the.
If this is an offers to settle.
No, the offer.
Things that I really cannot consider.
No, not the offer to settle, Your Honor. When he talked about earlier about the offer to order some other pavers to replace the chipping and spalling, the reason we did not accept was that they just continue to chip and spall. So that would have just replaced some pavers.
The
wrong application once again. So that's why we did not accept their offer.
I'm sorry, ma'am.
Claim.
I'm sorry. I'm still I need you to point a little closer. I'm very sorry about the technological issues.
Yes, Your Honor. Isn't there a timeline with the court system that you have to make a claim with a builder or whoever?
Yes, it's called the statute of limitations. There is a limit to how long you can go before you file a claim.
And that's why we waited until now, because we didn't want it to expire.
I understand. All right. Anything
Thank
further?
you, Your Honor.
Nope. Thank you. All right. I'm prepared to make a determination at this time. So based on everything that I've seen and from what I heard from Mr. Clens, it is clear that the pavers that were selected and installed for this driveway were not proper for this application. It's not a manufacturer failure as far as the material. It's not a failure material, as Mr. Clens indicated. There's nothing wrong with the manufacturer of the concrete pavers. They should not have been used for a driveway. It's clear that the chipping and sculling is a result of that improper application of those pavers. And so I think it's clear that Mr. and Mrs. Chris have established that this is a problem, that it's due to the wrong pavers being put in these driveways. However, I'm looking at the standard warranty. And Mr. Hoyt, your reliance upon the exclusions from coverage is misplaced. That subsection A, imperfections that result from characteristics common or inherent in the materials, indicating cracks which occur in the normal drying and curing of concrete, stucco, plaster, bricks, or masonry. Even if you were to call these bricks, that's not really applicable here. What is applicable is the very last paragraph in bold, where it says this warranty is the only warranty extended to buyer by seller. All other warranties expressed or implied, including the warranty of merchantability and fitness for a particular purpose, are hereby disclaimed. If something is installed that is otherwise manufactured properly, but is installed for the wrong purpose, is installed for a purpose that is not intended, that is whether or not that is covered by warranty. That warranty is called fitness for a particular purpose. I'll give you an example. Not that long ago, I had a somewhat similar matter brought before the court, where a custom bathroom was installed at someone's house, and they had slanted windows installed. The manufacturer of the windows had never specified that these windows be installed anything other than at a vertical. Beyond a certain degree vertical, they are prone to leaking. So they were not installed for the purpose that they were designed and engineered and manufactured. There was nothing wrong with the engineering, manufacturing, and design of the windows, but they were installed for a purpose that were never intended to be installed. So the question then is there a warranty extended by the seller to cover installing materials that are otherwise fine, but being used for a purpose that is not intended? And that is what we have here. The problem is the warranty, and by the way, if this disclaimer was not put in the bottom, that warranty would be implied. The manufacturer inherently implies that the materials that I use to build this driveway are being used for their intended purpose. That is an implied warranty, and the manufacturer would be stuck with that and being liable for any damages caused by using material that are not as intended. But they expressly disclaimed that warranty and said, we are not extending that warranty. We are not covering fitness for a particular purpose. And because that warranty is expressly and clearly disclaimed, the manufacturer of the home and then of the driveway is not liable for using these materials in that way. So I do find in favor of the defendant. And I said, this is not because I think that, Mr. and Mrs. Chris, that you fully and clearly established what the cause of the problem was, how it happened, why it happened, that it is a problem. I think you've proven all of that. It's just that there is no warranty extended by the manufacturer to cover that. They expressly disclaimed this type of issue from the warranty, and so they're not legally obligated to cover it. And that's why I find in favor of the defendant. All right.
Was that
I'm sorry, ma'am, I can't hear you.
the warranty signed?
I'm so sorry, I still can't
The
hear you.
standard warranty, I don't see a signature on that.
Well, it was testified that this is the warranty that is done on every single home in that neighborhood. So if this is the warranty that was extended
But there's
for every home in that neighborhood, if this is the warranty that's extended for that home, then there's an express disclaimer for this type of claim that they essentially said, we are not extending a warranty for this type of issue. And so because of that, I said that they're not obligated under this warranty to cover that kind of damage.
But Your Honor, we don't have anything signed by us or by them regarding the warranty. Maybe there is, but we don't have
The evidence that they presented has signature.
no
on it.
signature by either party regarding the warranty.
Are you telling me that this is not the warranty that would be used to cover that you might have received?
I'm saying that what they put in their exhibit, I don't see a signature on that.
No, there's no signature on it, but that's, the signature is not the end all be all, whether or not it applies. And Mr. Hoyt has indicated that this is the warranty that the manufacturer extends for these homes. Mr. Hoyt, does your company ever negotiate any different warranty or anything along those lines?
Our company keeps to our agreements. I did not enter this document into the record. This is their purchase contract.
Okay.
Initialed by them, initialed by us. Page 8 of that contract lists exhibits. Onto that exhibit E is a standard warranty. And then attached to that contract is that language in their contract. Right there. Has our signature on it, has their initials on it. Now, I don't know. I can tell you.
All right. So folks, like I said, you established your case. The basis of your claim, I think, was well established. The problem is they expressly, at the time of the sales contract, said that they won't cover this type of claim. That's what fitness for a particular purpose is. That's what this claim is that there's nothing inherently wrong with these pavers, but they are not designed or intended to be used for a driveway. And so the claim for that is fitness for a particular purpose, and they did not warranty for that. And so they're not obligated to cover it. All right. Thank you, folks. Thank you, everybody.